Ladies and gentlemen, welcome to today's webinar on compensability of COVID-19 under workers' compensation. My name is Andrew Keneally. I'm WCRI's Communications Director. We're so glad you could join us. Just before we begin, just like to tell you a little bit about WCRI for those who might be new to the Institute. We are an independent, not-for-profit research organization providing high-quality, objective information about public policy issues involving workers' compensation systems. We serve as a resource for public officials and stakeholders, but we do not make recommendations or take positions. Studies are peer-reviewed with a focus on benefit delivery, and we enjoy diverse membership support, including government agencies, employers, insurers, labor unions, service providers, and many others. And it is at this time we'd like to thank all our members who are joining us today. Without your support, we wouldn't be able to provide events like this and the research that we do. And if you're not a member, we hope you please will consider it. About today's webinar, the webinar is 30 minutes long. That's 25 minutes of discussion and 5 minutes for your questions. We might go a little bit beyond those that time set aside for questions. We'll see how many come in. To submit a question, use the questions box located on the right-hand side of your screen. Actually, if you want to identify that now and just simply write in the box that I'm coming in loud and clear, that would be great. Just a great way for you to also become familiar with it. And if there are some questions that come up during the presentation, feel free to drop them into it, and we'll try to address it at the Q&A portion of the webinar at the end. If you miss anything, don't worry. The webinar is being recorded and will be emailed to you after the event. We'll also put it on our website. And at the end of the webinar, we ask that you take a short online survey. For every completed survey that we receive, WCRI will donate $2 to Kids Chance, which is a great organization that I'm sure many of you know that provides educational opportunities and scholarships to the children whose parents were either seriously injured or killed on the job. Here's your interviewer for today, as well as our featured guest, Dr. John Ruser, President and CEO of WCRI, and Judge David Langham, Deputy Chief Judge of Compensation Claims for the Florida Office of Judges of Compensation Claims at the Division of Administrative Hearings. And with that, I'm going to pass it along to John. John?
Thank you very much, Andrew. Judge, it's an honor to have you on this webinar to share your views on the compensability of COVID-19 claims. But before we dive into the topic, I was curious to know how things are going in your court system in Florida.
Oh, well, thank you for asking. And please, Dr. Ruser, please call me Dave, and I'll call you John. We have had to make some adjustments here in Florida, not as pervasive as we've heard about in other states, but we have mandated mediations go telephonic here. We have seen a marked decrease in the number of hearings that are occurring, but we are holding hearings, many of them remotely by video like this. And we have seen a marked decrease in both our petition for benefits and general overall filing volumes. So it looks like COVID is slowing down the workers' compensation system, not speeding it up.
Thank you. So before talking about the present, how have diseases and particularly viruses been treated in the past in workers' compensation?
That's a great question. It's also a very broad question. And in fairness, we have to think about, first of all, that we live in a federalist country. And so we have a separation of powers between national and state government. And traditionally, we have had a workers' compensation system that has been state by state. And so when we ask how it's traditionally been handled, we have to keep that in mind and understand there are at least 55 non-federal workers' compensation systems in our country. And I know you'll make fun of me and say there's only 50 states. I get that. But Puerto Rico has a workers' comp system, as do the Virgin Islands and Guam and the District of Columbia. And so we have to look at the broad spectrum. And I've chosen two sort of pole stars to give you examples. One is Arkansas, which does not generally provide coverage for what they call ordinary disease of life, or diseases to which the public is generally exposed. And on the opposite end of that spectrum is Hawaii. Hawaii, which was mentioned in a Tom Robinson blog post earlier this week, also featured by Bob Wilson. Mr. Robinson describes to us that Hawaii offers coverage for virtually any viral infection, and the case on point that he cites in discussion is the compensability of a simple flu bug. So I think between those two poll stars, you've got a lot of different potential outcomes you could have state by state, and it might be difficult to characterize it as being easy or hard. Now, what's important about that is I think folks need to remember and realize that workers' compensation, whether we like it or not, is largely about drawing boxes or drawing circles around things that are included in a set and things that are not. And so as states have made those decisions about whether they will or will not have compensability for things like viral infection, they're making a choice about the population of things that will be covered. And when we talk about that population of things that will be covered, then we start to talk about what the price would be, the cost to cover those various items. And so I don't think there's an easy answer. The answer is essentially that there's a spectrum of responses. Some states are more liberal with viral infection, some states not so much.
Been a conversation about about how to treat COVID-19, and so things are changing a little bit. So could you comment a little bit about the way things are changing?
Sure. And I think first we have to think about why are things changing. And I think the reason for the why comes down predominantly to the fact that we've got a virus we're facing that does not have an effective human intervention at this point. So if this was something that we could have a vaccine against, I don't think you'd be seeing the reactions that we're seeing, either economically or medically or in workers' comp. This is a different kind of threat for that reason, and it's a threat to virtually any of us, all of us, at any moment in time. The other thing that's different is that by and large, when someone has influenza or a cold, when they're contagious, they're also symptomatic. And we kind of know to avoid the person that's got the bleary eyes, that's constantly sneezing, or has a runny nose. And with COVID-19, we've not been able to do that. We're struggling to identify who's got it and who might be communicating it. So both of those things, I think, are coming together in a way that causes us to question whether there need to be different other reactions. And we're doing that with the economy and now medically. So what are states doing? Again, in a federalist system, the states are acting independently. All of the state governments are three-branch governments, so there's separation of powers between an executive branch, an executive judicial branch, and legislative branch. And so in those states, we're seeing constitutional challenges to the way the various agencies or powers are acting or reacting and trying to deal with this new threat and the novelty that it imposes upon us. We have seen in recent weeks legislation that has passed. We've seen legislation actually come to pass in a couple of states. We've seen it introduced in a whole other list of states that not necessarily have passed laws. States like Louisiana, Massachusetts, New York, Ohio, Pennsylvania, Vermont have all introduced bills. We can't ever get too excited about a legislator introducing a bill because we know it's a long path from bill to law. So we'll see if any of those actually come to pass and are enacted. We have seen some statutes enacted in a couple of states, and so from that we're going to perhaps see a more long-term effect on the broader concept of viral disease in the workers' compensation community. Frankly, where we've seen the bulk of the activity has not been in the court system, it's been in the executive branch. And we've seen either commissioners or governors stepping in and imposing a really broad variety of executive orders and emergency actions to try to deal with both the infection and with the economic import of the infection. So, you know, where have we seen that and how pervasive is it? Well, back to the Arkansas example. In Arkansas, we've got an executive order that simply says we're going to ignore these statutory prohibitions on the diseases to which the public is generally exposed. And that it really is just a statement that for the time being, in the near term, we're going to have a limited focus of the law. Now, that may be challenged. On the other end of that spectrum, we've seen states like Washington and Kentucky, which have enacted very broad extensions of their law, not just that viral infections could be compensable or could be problematic, but that they would be presumptively so. And presumptively so for who? We're seeing it primarily for what folks like to call first responders, which is a sort of easy group to define because for years we've had first responder presumptions being enacted across the country. So we're talking about police officers, firefighters, paramedics, sometimes correctional officers. And then we're seeing the states like Kentucky, actually, and Washington go much more broader and talk about not just first responders, but what they're calling frontline employees. And frontline has been so broadly defined as to touch on folks like grocery store clerks. These are people that the state executive is perceiving as being at a particular risk for contracting this disease. I think that's part of their analysis. I think the second half of their analysis is a sort of parade of horribles or a what if, and that is, what if you picked up the phone and called 911 and they had no one to send? What if there's no one to put the groceries on the grocery store shelf and open the front door so that we can feed ourselves? And so those two risks, I think, are coming together and driving these executive orders. Now, by far, last week we talked about the most pervasive of the executive orders, in my opinion, is California's. Governor Newsom in California has instituted a presumption similar to the Kentucky and Washington tasks that has made it applicable to anyone who goes to their place of employment. Now, he specifically excluded those who work at home because, as we all remember, the ripples from several months ago with that individual in a Florida employment that got hurt in her kitchen. We're seeing a lot of debate about folks who work at home and what does or doesn't arise out of employment. Here, Governor Newsom has removed that by saying if you work at home, that's not your place of employment for the purpose of this presumption. But otherwise, anybody in California that gets a diagnosis of the coronavirus and has been to their place of employment in the last 14 days is presumed to have a compensable occupational disease. And so that is going to be the most systemic in terms of its depth and its breadth. Where we will see the limitation of that is the governor's action only covers a period of about 100 days since early March and stretching forward from now about 60 days into the future. So it's really a broad spectrum of responses, John, and I think it's intriguing from an intellectual standpoint, and it's going to be interesting to watch how it all develops.
Very much for that, Dave. Andrew, I think now it's time for the first of our poll questions.
All right, John, we're going to launch the first poll question, which is, and I'm going to launch it now. So if everyone can see it on their screen, the question that we're asking is, should state workers' compensation systems cover all essential workers? For example, nurses, police, grocery, etc., for COVID-19. And so the choices that you have are yes, no, and unsure. So we're going to give you about a minute to put that in. And aside from this poll, we do want to apologize for some of the audio problems we are having. Obviously, there's a little delay, and you know, you can test these webinar programs as much as you can, but sometimes we do have a lot of people on today, and so we do apologize for it, and we obviously will send you a recording at the end following the webinar in case something was unclear. Can everyone see the results? So we have, so the yes is 56%, no 25, right, and we have 18 that are unsure.
No, so I know that Dave wanted to make some comments while we were doing the poll. I'll maybe give him an opportunity to do that now.
Just wanted to point out one of the things about this whole situation that sort of gets under my skin a little bit is we define essential employees, and nobody seems to ever mention the insurance industry and the attorneys. And the fact is, the case managers, the adjusters, the attorneys, the paralegals that are keeping these cases moving and helping folks get to resolution or to settlement or to get a benefit, in my book, they're all essential employees, and I think they deserve a pat on the back that's commensurate with what we're giving others that are going above and beyond to make things.
Maybe, Dave, I could ask you about the easing of the burden of proof, and from your perspective as a judge, you could talk a little bit about how the burden of proof is easing, particularly with the move towards presumption?
There's a school of thought in this country that really the burden of proof is the critical workers' compensation issue, and that is because the party that has the burden of proof is going to have the more difficult time prevailing. Now, traditionally in our court system, we've always had the moving party bear that burden of proof, and so if you're being prosecuted for a crime, it's the state's burden to come forward and prove you guilty. You go into the system presumed innocent. And in similar fashion in our tort system and our workers' compensation systems, the defendant or the employer and carrier come in most of the cases presumed to not be liable. And it's the injured worker who has the burden of coming forward and demonstrating that they actually have had a compensable injury, that it fits within the parameters of the law, and that they're entitled to whatever benefit or benefits they're seeking. So all you do with a presumption is you alter the assignment of who's going to bear that burden of proof. Now, keep in mind, and I think this is a critical element with COVID or with any viral infection, it's going to be very difficult to prove compensability or lack of compensability in a viral setting. Very different than things like pneumoconiosis, which is a string of occupational diseases that we have a much easier time with as doctors and lawyers. If you have silicosis or asbestosis, or if you have black lung disease, if I come down with black lung disease, there's a really good argument that I got it mining coal, because frankly, none of us keep black coal dust in our homes. We don't go places that have black coal dust. It's not in the supermarkets. And so if you come down with black coal disease, well, that really makes sense that it's occupational and it's related. Viruses are going to be more difficult. The problem, particularly with COVID-19, is by the time you realize that you've got it, you may not be able to point a finger and say, well, I remember that person that was hacking and coughing that I probably got it from. For all we know, you got it from somebody that had absolutely no symptoms. You may have gotten it in the grocery store. You may have gotten it at work. You may have gotten it walking down the street. There's just no telling. And so if the presumption is put into play, as these states have done it, whoever's got that presumption on their side, whether it's the states that haven't acted, in which case the employee is going to have to prove they were exposed, both exposure and dose at the workplace, or these states that have presumption, that's just going to change it where the employee can say, I have COVID, you should provide benefits, and the employer carrier is going to have to come in and try to prove that they got it somewhere else. I personally think in either one of those settings, whoever has the burden of proving is going to be in a pretty difficult corner, John. I think it's going to be a tough case to prove. I think it's going to involve a fair amount of expert testimony.
Andrew, we have another poll. Do you want to put that up?
And we do again apologize for the sound issue. Obviously, there does seem to be a little delay in terms of the sound and the video. And don't worry if you missed anything, because we will be sending you a copy of the webinar after the event today. All right, so we're gonna close the poll now and put up the results.
Great, thank you, Andrew. I was thinking the poll should have said, are John, Dave, and Andrew on Mars, given the lag that we're experiencing. So I'm going to conclude the Q&A with the question to the judge. Do you think that COVID-19 will permanently change the way that communicable diseases are treated in workers' compensation? And do you see any implications for the viability of the systems?
I think that's also a great question. If you follow the national news, you'll see that several national elected officials in Congress are now proposing, at least to begin discussing, some sort of a backstop or reinsurance on a federal level of workers' compensation with COVID in mind. That might be similar to what we call the TRIA package that was passed after 9/11. I don't know that they can get that passed. I think 9/11 was a very emotional time for a lot of people, and I think that there was a real drive. It's become increasingly difficult to reauthorize that act each time it's come up for expiration, so I'm not sure that will happen. I think as legislatures reopen around the country, however, you're going to see more bills introduced that propose solutions to these issues that surround the idea of viral infection and the impact it can have on employers and employees alike. Whether they'll be specifically in workers' comp, I can't say, but I think many of them will be. And I think states are going to debate whether the cost of covering those kinds of infections is worth the state of mind, the peace of mind, if you will, that would come from employees and employers having that sort of safety net or backstop behind them on a state level. Do I think it will change workers' compensation? I do. How markedly it will change it, I really still have my reservations about, because I'm just not sure, A, how much this is going to create in terms of losses, and B, how willing or how able legislatures are going to be to come up with innovative and intelligent ways of dealing with those challenges and problems. So yes, a change, not sure how much.
Well, thank you very much, Judge Langham, Dave, for those wonderful answers to the questions. Andrew, I believe we have about 5 minutes for Q&A from the audience.
That's right, John. And our next question comes from Brad. How likely is it to be ruled that contraction of COVID-19 will be defined as an occupational disease and therefore compensable for workers' comp?
Well, that's also an excellent question. The precursor to that question and answering it, of course, is, are we in California or are we in Florida, or are we in a presumption state or a non-presumption state? We got to answer that first. The odds of it being compensable in California, I would say, are somewhere close to 100%, because the question that really is the only stopper there is whether you have or haven't been to your place of employment in the last 14 days. If you have been, it's presumed that you got it at work. Now, what's an employer going to do to defend against that? Are they going to go out and take nasal swab tests or these blood tests from everybody that you've been in contact with for the prior 14 days to try and find some other avenue to prove that you were exposed? I think the cost of that's going to be prohibitive. A lot of experts involved, a lot of time involved. I just don't see it happening. Now, if you're in a non-presumption state, I think that it's going to be very difficult to prove compensability of COVID, just like it would be very difficult to prove compensability of influenza. Well, the fact is, we get these germs on our hands. We touch doorknobs, we touch car doors, we touch all kinds of things all day long. You probably haven't noticed 3 or 4 times during this, I've touched my face, which you're not supposed to do, and I do it anyway. And so it's very easy to get this viral infection. I think in those states, Arkansas, even though it's going to allow the compensability, I just don't think you're going to see a lot of those cases prevail, because it's just going to be a very, very difficult burden of proof, and again, very expensive to prove.
Our next question comes from Timothy. Can a governor's executive order regarding a causation presumption for first responders who contract COVID-19 counteract statutory provisions regarding causation standards?
That's a great question. That's fundamental government and civics from when we were in high school. And a lot of pundits out there are at this point saying, no, it can't. And they're arguing that various governors around the country have stepped out of their lane, if you like that modern colloquialism, and that they're acting beyond their constitutional powers. We've already seen some reaction. One of the first states to come up with an expansion of presumptions was Illinois. Their governor didn't create it. The commissioner of their workers' comp system did. It lasted for about 18, 20 days, and they withdrew it. They withdrew it because business filed a case in court, and they got a judge to find that the commission had overstepped its legal bounds. So are we going to see challenges? I think we might. The real question is going to be, will the costs become pervasive enough that it's worthwhile to pursue litigation? Like it or not, litigation is expensive. And so if these presumptions don't create huge cost impacts in a jurisdiction, I don't think the cases will probably get filed. If they do start to create financial impacts that are significant, I think you'll see the cases get filed, and I think you'll see separation of powers argued. And depending on the state and its laws, I think some of them are perhaps susceptible to the same sort of retraction or overruling by the courts that we saw in Illinois.
Next question comes from William. Isn't the categorization of workers into essential versus non-essential a game changer? That is, if an essential worker leaves his or her house during lockdown period, specifically because they are an essential worker going to work, why wouldn't that trigger coverage?
Yeah. Well, and when we use definitional words like essential, I mentioned earlier, workers' comp simply draws a box or a circle around what is going to be compensable, who's going to be compensated and who's not. And those are policy choices that legislatures make about where those lines should be drawn. And I'll be the first one to tell you that I've talked to many people that believe some of those lines are rather arbitrary around the country, and they characterize them as not being fair. And I think there's probably merit in the argument on both sides of that. So if someone who's essential merely steps out of their environment to become out of their home, should that or should that not be a compensable event? Depends on where you draw the line, and it depends on how you define essential. I think it's all very difficult, and it's going to be fact intensive.
Next question comes from Nancy. Can you describe the difference between a rebuttable presumption and a conclusive presumption?
Well, the courts have done that, and frankly, most courts find it difficult, and they say a non-rebuttable or conclusive presumption is what they refer to as a bad presumption. The rebuttable kind, you can come back with proof to the alternative. So if this first responder presumption for COVID-19 is rebuttable, then the first responder, the police officer, files a claim and says, I've got this disease, here's the doctor's note that says that, you should have to pay for it. To rebut it, then the employer would have to come back and do maybe what I described of contact tracing and trying to figure out where else this person may have gotten this disease other than in the course and scope of their employment. And if they can conclusively prove that, and how might they prove it? It could be extremely difficult, but what if that police officer, it turns out, has been caring for their elderly parents who both were diagnosed with COVID-19 well before the police officer was. And so now, goodness, Judge, we can put this COVID-19 in the police officer's home or environment, and it was there and it's demonstrable, and you really should believe that it was the family that gave this officer the infection and not the work. That would rebut it. The reason we don't like conclusive presumptions, and the reason that courts don't like it, is because you can't come back and provide any truth or any rebuttal alleging truth. And so a conclusive presumption, it's true no matter what you think of it being true. So a rebuttable presumption deprives you of your opportunity to be heard, to tell your side of the story. And so if we make it a conclusive presumption, then what the law says governs and rules, and people cannot demonstrate why it should not govern and rule them. And in our democracy and our society, we deem that to not be appropriate except in some very extreme circumstances. So that's the distinction.
Our next question comes from Stephen. I'd like to know how Florida has treated viruses in the past.
Well, we just had two very interesting cases decided late last year. When we have infection in Florida, it's the burden of proof for the injured worker to come forward and demonstrate that it is both arising out of and in the course and scope of employment. And so it's difficult for an injured worker to prove. They have to prove not only what substance they were in the presence of, but that the presence of that was there was sufficient in a medical expert testimony setting to demonstrate the likelihood of the effect, that is the onset of the disease and the symptomatology. So it's been very difficult here, and I think it remains so today.
Our next question goes to Beth. If in a state where workers' comp covers viral infection, should medical billers submit claims to workers' comp if the patient believes they were exposed to the virus while on the job? What should be documented in the medical record to support that claim?
Yeah, and I think that's really difficult because at the outset, when you get somebody that walks in, a patient, and it should be, our primary concern is about alleviating symptomatology. It's about making somebody well or better. And it's not about how do we get our bill paid and how do we document things. Unfortunately, in our society, we've kind of twisted that around, and a lot of our focus and concern now is on these ancillary issues. Uh, I've got a friend who's a doctor and mentioned to me one day how many people were on his staff. And I said, my goodness, your office isn't that big. He said, Dave, half of those people do billing and follow up with the insurance company. That sort of surprised me. So if you have a health issue, you're a group health insurer in a state that has that presumption, I think that probably what you're going to do is you're going to deny that coverage, and you're going to let them look towards the workers' comp carrier. Probably the better thing to do for that patient would be to pay those charges, and if it's really workers' comp, then turn to their workers' comp insurance carrier and go after them yourself to keep the patient out of the mix and out of the problem. Does that raise the group health insurer's cost? Absolutely. But the group health insurer didn't get the disease and didn't have to deal with the recovery. And let's face it, even in the best of times and the best of health, dealing with insurance contribution and reimbursement and things is just above and beyond what most of us are capable of doing on a day-to-day basis. So I think that's the best answer.
That's great. Now, just for those who are listening, we are taking a little bit more time during the Q&A portion. We know we had some audio difficulties at first. Things seem to be working very well now. And I've already talked to the to the interviewer as well as our featured guests, and they have said that they will allot more time to answer some of these questions. So we're going to go for a couple more minutes if that's okay. Our next question comes from Jerry. How could a disease of life, 60 to 80% of population are expected to contract it regardless of employment status, and the resultant illness is predominantly driven by underlying health issues and status rather than the virus itself, possibly make the criteria for the fundamental framework for compensability?
And the easy answer to that is it cannot meet the fundamental framework for compensability. The way that the statutes were drawn and amended historically, it just would not meet that, except in states like Hawaii that made a conscious decision to include those sorts of things. So what you're seeing is not necessarily about science. It's not necessarily about the law. Again, it's a policy choice of where do we draw the lines of what's included and what's not. And then we can get into discussions about what's fair, and any discussion about what's fair, you have to take into account perspective. That is, fair to whom, and fair to whom and when. So I get the fundamental foundation of the question, and I agree it's very difficult, but the fact is policymakers are elected to make those kinds of decisions, and we'll see what courts do in terms of whether executives have the authority to expand statutory benefits in the way that we're seeing across the country.
Before we jump on our next question, I must say we're getting some great questions right now. And our next one comes from Bill. How is Florida handling in-person hearings given the ongoing social distancing protocols still in place? Are you limiting the number of people in the courtroom?
Well, what I believe in very strongly as Deputy Chief Judge is judicial independence. I think those decisions are best left to the individual judges. We don't have, in our 17 district offices, we don't have uniformity in terms of the size of the hearing rooms that we have, the size of the waiting rooms, and so we're leaving that to them. Many of our hearing rooms are already set up in a courtroom type of appearance where there are separate tables for counsel on each side and separate places for folks to be able to sit. In those larger hearing rooms set up that way, we can certainly social distance. In other settings, not so much. We have smaller hearing rooms that don't have those separate tables. They have one long table in the center of the room. That's going to be more difficult and more challenging. From my personal perspective, as I've had trials come up over the last few weeks, I have urged folks, the attorneys, to agree to go with a video hearing over a platform on the internet, just like this. I'm confident that most hearings we can handle in this manner and in this fashion. If we do have to get together in an in-person environment, then we're going to look for those larger rooms, and we're going to rearrange the furniture in some of them so that we can keep folks with that 6-foot distance that the CDC recommends. And we are requiring folks that come to our office in person to follow the recommendations and wear a face mask. And that's the best that we can do at this point. I keep stressing to people, and let's all remember around the country, we're not not in a position today to ask ourselves if we'd like to have it the way it used to be. What we can ask ourselves validly is, are there ways that we can progress, that we can make progress and get folks through our system, get them what they need on either side of the case, that's perhaps less than it could have been, less than perfect, but good enough to get this job done that's so important for injured workers and their employers.
All right, Judge, last question, obviously, that we have time for is, how do you keep track of all the changes that are going on right now with the various presumptions and state actions?
Well, I think if anybody tells you that they're able to keep track, they're either lying to you or they're lying to themselves, or they're a lot smarter than I am. How do I keep track of it? I spend probably between an hour and a half and 2 hours a day reading what I call the dailies. I reach out to various platforms that cover workers' compensation news. I have set up Google alerts in my browser so that when stories that mention certain things together, like workers' compensation and COVID-19 are published, they come up in my news feed and I get a chance to have a look at them. And admitting my age much more than I would like to, I'm keeping copious notes of things. When I find an article that I think is interesting or expresses a different perspective, I'm emailing that article to myself, and I'm trying to just keep a list of links to those articles and periodically trying to put them in some sort of a summary form or fashion so that I have an idea of where things are going in a general sense and then in the more specific state by state. But it's challenging. I don't think anybody's doing it entirely effectively. I really don't. Great.
Judge, any last thoughts that you have?
Well, my thought is I think this went swimmingly, and this is just an absolutely a great platform and a great idea for us to get together and talk like this. And at the risk of offending those 9 folks at WCRI, I would suggest we did more of these, and you should reach out and get some other folks on the line, because I think this is fantastic, even though I know it makes an awful lot of work for you folks. I think it's really good.
Well, great. Well, that's all the time we have for today. As we said, we will be sending you a recording of the webinar before the end of the day. We do apologize for some of the audio issues at the beginning and some of the lagging that occurred. Hopefully, it will look better on the recording. The recording will also be available on our website. So I want to thank both our interviewer and our featured guest for a great discussion on a very important issue. And most importantly, we want to thank you for joining us today, and we hope to see you on a future webinar. Have a great day, everybody, and thanks for joining us.
Thank you.